And with that, I'm going to go ahead and start. I'm Steve Traylor, Executive Director of NATOA. I'm kind of a last-minute fill-in for a moderator, and at first we thought we would just have Gary and Tim sit up here by themselves, but two attorneys with no one to moderate their time only spells trouble. So I do want to introduce our two speakers. We have Tim Lay. Most of you know Tim from Spiegel and McDermott up in Washington, D.C. Tim's full bio, as well as the bio for Gary Resnick, is available on the NATOA conference app. So if you go to the app, you can pull up their picture and their full bio and really find out more about them. But just on a personal note, a lot of you don't realize how much behind-the-scenes work Tim does for local governments up in D.C. He's presently involved giving the National Association some advice on some pending legislation that can really affect telecom taxes and revenues. So kudos to Tim for that work. Our second speaker is Gary Resnick. Gary's a longtime member and former board member of NATOA. He is currently the mayor of Wilton Manors, Florida, which is where I have a home. So welcome, Mayor.
Appreciate it.
And Gary is also a representative on the FCC Intergovernmental Advisory Committee, along with a number of other NATOA members. So Gary keeps that committee up to date on what is a concern to local governments, and then relays that information back to us so we can share it with you. And with that, I'm going to go ahead and hand it over to Tim.
Thanks, Steve. Am I on? Okay, mic's on. Hi, everyone. As you can tell, this is a pretty broad topic. It's one that you could spend an all-day or a two-day seminar on. And I don't know how much time I have, Steve. Probably, what, 20 minutes, something like that?
Yeah, something like that. I'll catch up sooner.
So I could try to talk at an incredibly rapid pace, which I sometimes do, but that's not a very good presentation method. So what I'll do is give you sort of a 28,000-foot view level of what some of the issues are, or at least in my mind. And to do that, we have to put it into a little bit of context. What I thought I'd do is sort of in a caution. This is a gross oversimplification both on the technological side of where we've been, and I'll have a slide later on the regulation side. And those of you who are real knowledgeable will say, well, Tim, what about this or whatever that? And there are exceptions, and that's correct. What I've tried to do is give you a little bit of an overview of where we've been so you can understand what the issues are going forward. And I'd start off a little bit in technology. It's always dangerous because to have a liberal arts lawyer talk about technology, a little bit of knowledge is a dangerous thing, and in the famous words of Dirty Harry, a man's got to know his limitations. But what I was going to do is give you a little bit of a background on the prior technology, or sort of pre-IP technology, because it also will feed into how we've historically regulated them. And I've broken it into three categories: telecommunications, broadcasting, and cable. That's an oversimplification, but it basically, and which you'll see below each box, and by the way, I've sent in this PowerPoint, so you'll be able to get it, your own wonderful, colorful copy at NATOA, and there are a couple of glitches in it that I'll point out later on. But as you'll see, telecommunications, basically, I would call it pure information transport. I mean, what it is, historically, is the way individuals communicate with one another. You send your message, and a carrier sends it to where you want it to go without fiddling around in the content. You're the editor, not the information transporter. It's just a pure information transport function. The classic early example of it, of course, is telegraph. I point out telegraph for the rather simple reason that a lot of people think of telecommunications as voice services. That it is not just voice. It never has been just voice. And even in the current Telecom Act of '96, it is the transport of information, not voice. But industry has long pushed the argument, which I think a lot of states have fallen into the trap of thinking of telecommunications as only voice service, and that's never really been true. Although clearly from an end-use residential standpoint, historically, that is primarily what it's been. But what's interesting about it is it's switched, and it's point-to-point. Broadcasting, all of you all know about. If you're as old as I am, you grew up with broadcasting before cable. And it is obviously point to multipoint, and it's wireless. Cable, of course, is the hybrid. It is landline, but it is sort of historically structured. It's much more structured like broadcasting. That is point to multipoint. It's basically a retransmission of video signals either the local broadcaster or satellite video channels receive. What's interesting about the broadcasting cable model technologically This doesn't have to be true technologically, but I'll state in a minute why regulatorily that's been true. The telecommunications side, the owner of the network does not control content. The owner of the network is just a shipper. Ships information here, there, and yon, doesn't control content. The broadcasting and cable model, of course, it's a point-to-multipoint service, so that isn't so surprising. Both of them, the owner of the distribution facility also, by and large, controls the content. IP, and this is where a non-engineer proceeds at his own risk, in this case, my considerable risk. It is actually a transport technology. And I'll get to that point in a minute, because part of the problem when we talk about moving to IP, what we're really talking about is a different transport protocol, is what IP is. But as most of you probably know, IP transmission has several characteristics that are different than the historical switched telephone network, and certainly different from the historical TV broadcasting and cable model as well. It's both landline and wireless. I will drop a footnote. A lot of people think that telecom was all landline before this developed. That's not true. There were radio common carriers for a while too, but it's also true that the wireless sector historically with the communications pre-IP was less common carrier. There was common carrier radio telephone service and paging, but it was less common carrier and more not just broadcasting, but private business radio, police radio telephone as well. Also, of course, IP is unswitched. What's interesting about IP is obviously it can perform a pure transport function, but IP networks, particularly last mile networks, can also perform content generation, manipulation, and storage. In other words, they can sort of do broadcast cable-like functions, and they can do telecom-like functions. The other thing that's interesting when I get to the regulation side is jurisdictionally, IP, since it's not a switched service, and it's also not like a straight radio broadcasting service or so forth, one of the characteristics is because it is packet-based, when you send an individual message, be it an email or whatever, or speak via VoIP, the bits that make up your message are all sent separately and can actually traverse different geographic routes. That has a significant jurisdictional impact because under the old-fashioned telephone network, by and large, and there were for some exceptions, there is a dedicated switched route between you and the person you're communicating with that is jurisdictional. You can trace where it is, and there's a single route. That is not necessarily true in the internet world. Now I want to get to the regulation part of it, and you'll see it follows along the technology I discussed earlier. Again, this is a gross oversimplification, so I'm sure there are folks who will actually point out some shortcomings or oversimplifications in it, but these are, you probably heard of, how many of you have heard of regulatory silos before? I suspect you have. Well, these are the three silos, historically under the Communications Act. And even that's a little oversimplification, but for present purposes. And the first one is telecommunications. That's also, if you've heard the term Title II, that's Title II of the Communications Act. Basically, that has to do with pure, again, the pure transport function, the responsibility of sending people's messages, individuals, groups, or whatever, and sending it without change in form or content to where the customer wants that information to go. Tied to that is what's called the common carrier duty. And the basic duty to serve, and by the way, this actually originated with railroads, and if you go back to common law England also with bridges, it's the obligation of basically to serve all comers at reasonable rates and not to unreasonably discriminate among all the various users. It's the basic transport information function. Under the Communications Act, historically, that was separated, interstate service exclusively regulated at the federal level by the FCC, intrastate service under the Communications Act is regulated exclusively by the states, primarily by state PUCs. And again, when it was a point-to-point switched network, that dividing line, although I won't pretend to say that it's an easy or simple one, it's gotten very cloudy over the years and there's lots of doctrines and exceptions to it. But that was sort of the basic dividing line. As I mentioned earlier, in an IP world, that line gets much more difficult to draw. Broadcasting, most of you are familiar with television and radio broadcasting. I won't spend a lot of time on it, but it is obviously not regulated according to the common carrier model. The broadcaster controls the mic and controls the transmitter. The broadcaster decides what messages are conveyed. Part of that also is, as a result, broadcasters enjoy a degree of First Amendment protection. I'll jump over to the model that you all are familiar with, probably, and that's cable. It too, as most of you know, enjoys some First Amendment protection. It is not a common carrier. The cable operator basically decides, with a few exceptions, what content is delivered over the system. And you also, the cable model is what I call sort of a mixed broadcast common carrier model. The only common carrier aspects of it really are, there are some capacity set aside requirements, all of which I suspect you already know about. You have broadcast must carry, you have PEG, of course, and you have commercial leased access. The other thing that's interesting about cable, and you all know all about that, is the mixed federal, state, local regulation model. I put state local because, as some of you have found out, the Cable Act doesn't really draw a line with what the franchising authority is. If the state, as a matter of state law, decides to have a state franchising authority, then as far as the Cable Act is concerned, that's a matter for the state to decide. But what's interesting about the jurisdictional boundary, the mixed federal, state, local regulation for cable, is it's very different from the telecommunications model. The telecommunications model is basically based upon end-to-end jurisdiction of the communications. That's not true in the Cable Act. A cable system is, of course, a local physical distribution system, but of course the content it carries, a large proportion of it, certainly all the satellite programming, is either interstate or international. So basically you have a functional division of regulatory responsibilities in the Cable Act as opposed to a geographic jurisdictional allocation of responsibilities. IP regulation, of course, I can't tell you exactly what it is because it's in the state of flux. And this brings up a point I said earlier, and that is that as a practical matter, historically in the silos, we've regulated services based upon the end user service. You know, gee whiz, is that voice communication service? Is it data transport? Oh no, it's video, it's television broadcasting or cable, and we look at the end-use service and we regulate based upon that. The problem in the IP world is that boundary can be blurred. The classic example that you know about is VoIP. VoIP can be an application, but a lot of services that look like end-user service in the communications model do not have to be network provided at all. They can be applications. But, and this is sort of like a shell game. I'll be a little bit of a cynic and say this is the shell game that industry plays to confuse everyone. You can move all the shells around, but underneath, there is still an underlying IP network whose function it is to transport information. You can move all the shells around on the retail services, but underneath all that, that's what the relevant issue is. Now, I could spend all day talking about the second bullet there. The weird and wonderful world of trying to distinguish between telecommunications and information services and what they are. But I'll just say that the FCC, and there are some open issues here, facilities-based interconnected VoIP has not been classified by the FCC as whether it's a telecom or an information service. But the FCC has tended to say that, oh, well, if it's IP-based, if it's broadband, if it's whatever, it's an information service, not a telecommunications service. And not only that, it might be inherently interstate, and therefore states keep out. Now, this is a sort of huge expansion of a philosophy that developed about 30 years ago in the FCC's Computer II proceeding. Of course, back then, all we were talking about is data processing between big computers, between different business locations and so forth like that, but that's spread over to the retail network now. But the other thing you need to keep in mind when we're talking about IP regulation and what the policy should be is several states, I lose count whether it's 27, 28, or 29, it's more than half, have at the request primarily of the local telephone industry, passed state laws that have basically barred the State Public Service Commission from engaging in any form of regulation of IP-based service or VoIP. Now, they do require VoIP to make contributions to 911, But outside of that, they basically have knocked the props out from under Public Service Commission regulation of these services. And in a slide in a minute, I'll tell you, well, that can have significant implications for what going forward regulatory policy will be about IP-based services. The last two bullets are some of the interesting questions that IP regulation presents that really haven't been answered yet. The first one, every one of you who's in a jurisdiction where AT&T U-verse exists are probably familiar with, and that's the issue of, as you know, AT&T takes the position that its multi-channel video service is not a cable service. And therefore, they're not really subject to the Cable Act at all. However, out of the goodness of their heart or graces or state law, they will provide things like PEG channels and pay a 5% fee, but they're not a cable service. And this goes back to the sort of magical thinking I talk about, that whenever you use the term IP or IP-based services, people think it's like the Great Oz or something, and it's this magical thing they don't understand, and whatever we do with it, we can't treat it like we've treated things in the past. This is all new. And the FCC has ducked this question. Ironically, it's ducked this question for a very long time. There is, as many of you know, the Alliance for Community Media's petition against AT&T's PEG product, which has been pending for over 4.5 years. But the issue actually came up before that in the FCC's IP-based rulemaking, and the FCC has never addressed or resolved what AT&T's services, although a district judge in Connecticut had no problem whatsoever deciding that, you know, if it quacks like a duck and it waddles like a duck, it's a duck, and that it is a cable service. AT&T successfully got Connecticut to change its law, so the Court of Appeals vacated that decision. But that decision, to me, is unbiased, admittedly, but to me, what AT&T is providing as a cable service is a very simple question, not nearly as complicated as AT&T makes it. The last bullet before I switch over is the over-the-top video question. There is the question, this isn't so much as to whether it's a cable service or not, but it is an issue presented at the FCC of whether it's a multi-channel video programming distribution service, which triggers various Cable Act requirements, but also benefits, and that's pending. And this is basically, by over-the-top video, if you don't know, I mean, the classic example is Netflix, Hulu. Basically, it's delivering multiple channels of video service over the broadband part of your connection, not the proprietary TV channel package that is offered by your cable operator or by your local telephone company. It comes over the just broadband internet access part of it, and it can be provided that way. Now I'm going to finally move to the regulatory implications. And here, the first point I presented are just really policy questions. These are issues that, oh, by the way, a warning ahead of time, these issues will come to bear in a blinking red elephant that you'll see later on. The threshold issue that industry presents when you talk about broadband, how do you treat broadband services, is, well, this is not a common carrier service. The FCC is not even classified as a telecom service. Well, if it's an information service, that removes all common carrier obligations, and gee whiz, we're like broadcasters and cable companies. We're First Amendment speakers. We get to decide what goes over our broadband network. If I don't like Tony Perez's viewpoints, then I don't have to carry his messages where they want to go. Now, they don't say that, but that's a logical implication of what they're saying. Or maybe I don't like it, but I'll let him have service, but he'll either have to pay a lot more or, you know, it'll be hard to reach him. And that is what a non-common carrier world is. Nobody has the legal obligation to carry your messages where you want them to go without changing content. Other than, you know, they can't violate generally applicable laws like the antitrust laws, but they don't have, no one has a legal obligation to carry your messages unless they decide they want to. And that's really at the First Amendment level. It's also at the statutory level, but the First Amendment level, when that issue is presented, that's the policy question we're talking about, and that's a grand experiment. I mean, for over 100 years in this country, since really the dawn of what we think of as communication services, someone has had the legal obligation. Now, we've removed some of the requirements. You don't necessarily have all these formal tariff filing requirements and all that kind of stuff that makes lawyers a lot of money, but it frequently is a lot of busy work. But the question is whether someone has a legally enforceable obligation to carry those messages. And the question is, if the First Amendment attaches to these providers, does that mean the end of that? No one has that obligation. Now, the marketplace, that's not to say the marketplace might, since there's a business to be made in that, and lots of people like to communicate, that someone might provide it, but the question is whether can anyone be compelled to have that legal obligation. But even if you move beyond the constitutional First Amendment issues, there is the issue of, okay, let's assume that they don't receive broadcast or cable level of First Amendment protection. How can we regulate them? Should we regulate service? And the real policy question that I'm sort of going toward, which you can probably tell from the earlier slides, is obviously IP networks in essence can perform telecom service functions. They can perform broadcast cable type functions. They can also perform functions we haven't, that neither one of those technologies ever thought of before. But underlying all that is also just basic information transport functions. Is there a way to separate those two functions out? And should they be? Or should we just treat IP networks like grocery stores? The reason I use grocery stores is obviously food, just like telecom service, is an essential service. But we don't subject grocery stores to common carrier obligations. We don't require them to carry Skippy, Peter Pan, and Jif, all three. We let the grocery store decide. We think that the market is sufficiently competitive that takes care of the issue. The separate issue is the allocation of jurisdiction, and given my shortness of time, although these are issues that you probably care very much about, the issue is if there's going to be any regulation at all, how do you allocate it? As I pointed out earlier, using the strict intrastate-interstate division can be rather difficult in an IP world. But there are other possible models, and the cable model is one. The cable model allocates responsibilities not so much by the geographic link of the communication, but by specific kinds of responsibilities. The other issue I want to point out, remember I said earlier a lot of states have passed laws forbidding the state and the State Public Service Commission from regulating any IP-based regulation. Well, the problem is, if that's true, if those laws aren't repealed, as a practical matter, if there's going to be any sort of public interest or carrier obligation imposed, it would have to be imposed at the federal level unless, if you want effective regulation, unless you can somehow persuade those 28 or 29 legislators to repeal their laws that the bells ask them to pass, and I wish you good luck on that effort if you want to do it. Here is, and again, we could talk all day about this, but a lot of these issues are presented, although they won't as... Yes, he's supposed to be blinking, I think. I hope he didn't do something he wasn't supposed to do, but maybe it would have been entertaining. But as most of you know, a week ago today was the oral argument in Verizon's appeal of the FCC's open internet order. Now, it will not resolve all the issues I've just brought up, but it presents a lot of them in direct and indirect ways. And after that decision, we'll find out a lot more than we know now about how those regulatory responsibilities will be allocated. The last thing I want to bring out is, as I've walked through this, and since all of you are local franchisers for the most part, the local government says, well, what does this mean for me and what I do? And the real bottom line there is, when I talk about regulation and I talk about rate and service regulation, which is what I've talked in all the previous slides, I want to say what I'm not meaning. I am not meaning right-of-way compensation and management. In other words, getting compensation for these providers' use of your product. I'm not talking about taxation, and I'm not talking about local land use authorities. Logically, there is no reason why service classification and rate and service regulation should interfere with those traditional historical local authorities. But I'll have to tell you, although logically that's true, whether that will end up being true is a very, very, very open question. As most of you know, on the tax side, you have the Internet Tax Freedom Act. I didn't add in there the draft Digital Goods and Services Tax Freedom Act, which could implicate the issue as well. But I guess I'll excuse myself by saying the ITFA is actually a law, the Digital Goods and Services is not. You also are probably familiar with Section 253, and by the way, that should be 332C7, not F, of the Act. And those literally apply to telecom services. But there is the issue of whether the FCC could use its Title I authority, either one, to extend them to broadband information services as well, or whether Congress would do so, or this last point, your friendly state legislature might. But those are very much the open issues for local governments, and with that, I think I'm fairly fit in with my time. I will sign off.
Thank you, Tim. Gary?
Good morning. How's everyone doing? All right, let me, how do we get to the, click to exit. Okay. How did you start the slideshow?
And you just use this to page over.
Top or bottom? Anyone understand technology?
Hit here for full.
Okay. Yep.
Nope.
Both of us. You got two lawyers and an elected official up here, and we can't do this.
Just click on that little button right there next to the 60, the last one. There we go.
There you go.
Hey. That was supposed to be a joke, I guess. Steve introduced me. I'm Gary Resnick. I'm a lawyer who practices telecom, representing property owners and public entities, as well as he mentioned, the mayor of Wilton Manors, Florida. And I serve on the board of directors of the Florida League of Cities and the Florida League of Mayors, so let me officially welcome everyone to Florida. We appreciate your business and the connections we have with DC, notwithstanding our governor turning back everything from DC. So thanks for being here and coming to Florida for the conference. I'm going to talk a little bit about digital leadership, and Tim and I really didn't coordinate our presentations, but it makes a lot of sense because, I mean, first of all, it's an honor and a privilege to be on a panel with Tim. I mean, I've constantly contacted him on any telecom subject, and he is an expert in every area, and I appreciate all the advice he's always provided over the years. I'm covering things on a much more local basis as to sort of more of the practical effects as to how the IP transition is affecting states and local governments as well as our consumers. So I'm going to talk a little bit about how quickly technology has become obsolete, that regulation and policy never keeps up with technology. And then, as Steve mentioned, I do serve on the FCC's Intergovernmental Advisory Committee, the IAC. I have the privilege on serving on that with Ken Feldman, as well as some other NATOA members. And we've been chiming in and submitting comments and recommendations to the FCC on IP technology and the transition that is occurring. So I'm going to talk a little bit about some of the comments that we've submitted. And then some of the issues that, that the policymakers are ultimately going to have to balance in the IP transition, and we'll end with some fun about things that may become obsolete. So who remembers any of these things, and when's the last time you used one of these things? We actually budgeted $600,000 for our public library this year in my city. Ironically, it's now a media center. We do still buy books occasionally, but the main usage of our public library is the computers, and which is a great usage now because our residents, a lot of them just do not have or cannot afford their own broadband connections or computers. So we'll see what else becomes obsolete in the near future as technology progresses. Okay, I'm going to start with some of the IAC comments, and this is a lot to read, so I'll just sort of summarize. The IAC, the Intergovernmental Advisory Committee, is comprised of state and local elected officials or their representatives and Indian tribes. So we've been submitting comments to the FCC on a variety of issues that the FCC deals with. And one of them that we submitted was back in January of 2013. We submitted some general comments regarding the technological transition from legacy copper wire to newer technologies. And we understand and support entirely that technology has to progress. And that's not an issue, and we don't want to do anything that stops that. But there are a lot of issues that, as Tim mentioned, arise when you talk about this technology progressing, and the regulations do not keep up with the technology. So let's just start with a summary of some of the issues that we highlighted. And by the way, a lot of our issues that we addressed are really more consumer-oriented issues, even though we're not per se a consumer committee, we're very concerned with how these transitions are going to affect the residents in our communities. The carrier of last resort issues is something that needs to be addressed in a competitive environment in which wireless, IP-based satellite, and other technologies exist to move voice and data communications. A legitimate question exists as to whether the requirement for a designated carrier of last resort should remain. As Tim mentioned, a lot of states have chosen to deregulate telecom. Florida is one of them. There are no longer carriers of last resort in Florida. As a result, there are many communities in Florida, and I represent several of them, that cannot get wireline telecom service from a local phone company. And they're not in rural areas. These are in urban and suburban areas. They just will not be able to get service from the local phone company. They just will not provide service to those communities. And there's nothing requiring them to do so. Another issue that we identified that needs to be addressed is what happens to universal service funds. These funds have focused on maintaining affordable rates for customers in high cost to serve areas by providing assistance to the incumbent provider of telecom services. So the question becomes, if you transition from these telecom services to an IP-based service, who is eligible to receive USF funds? And that's obviously going to be fought through not only the regulators, but also the courts. And if a company transitions from a legacy copper wireline service, should it no longer be eligible to receive USF funds? And these are just some of the issues that you can see up there that we've raised. And to frame this, maybe we need to start thinking about what is a basic service that all consumers should have access to. And it probably is no longer traditional wireline plain old telephone service. And our recommendation in this regard, and we still have yet to hear from the FCC as to a recommendation, but that's a whole nother story, and that's Ken's hot button, not mine necessarily. But we recommended that the FCC formally work with state and local government policy leaders and tribal leaders, actually, to develop more contemporary definitions as to what constitutes telecommunications basic service, regardless of the provider or technology. And maybe we need to start thinking more in terms of functionality and what function every person should be entitled to receive, as opposed to the technology that the person should receive or the provider that should be required to provide such service to the consumer. And there's also a lot of issues that we identified regarding consumer protection and consumer issues. And our recommendation in that regard was that the FCC was likely not in a position to deal with all the consumer issues that should arise. So there has to be some type of shared jurisdiction over these issues between the federal government and the states and local governments. We submitted a second round, more specific and more focused to the FCC. This is the second round of recommendations that we submitted, I think it was more recently, back in June of 2013. And this was in response to a technology transitions task force request for comments on potential trials of transitions to IP-based networks. So there is a docket out there that the FCC has issued asking for comments on holding public trials to transition from legacy copper technology to IP-based technology. By the time they probably get around to rolling out the trial, this would have already occurred. I don't know about you folks and where you live, but it has occurred in my area significantly. As I indicated, I live in Florida, obviously. I'm the mayor of a city in southeast Florida, right near Fort Lauderdale. And when I had satellite for video, the incumbent cable operator for internet, and the local telephone company for plain old telephone service, and I decided I wanted to basically stop getting 3 bills a month, and an alarm service as well. So I wanted to stop getting 3 bills or 4 bills a month. So I signed up for my cable company's triple play, okay? And I was promptly notified by my phone company that when I canceled my phone service and ported my number, that I would no longer be able to receive phone service from them. That if I decided to go back and obtain their phone service, I would have to take their IP-based voice product. and phone service would no longer be available because it's no longer available in my neighborhood. None of my residents in my city can sign up for plain old telephone service. So the IP transition has already occurred. The companies are not offering the plain old legacy service anymore. They are really only marketing their VoIP service and the other IP-based services, and that's causing a lot of issues. So, the IAC submitted these comments to the FCC about what factors should weigh into these IP trials that they're looking at holding. And I have to keep up with the slides. Our main concern in our first comment had to do with the preservation of services and affordability. We're very concerned that the services that people are currently buying and paying for remain available. And if they decide to move to an IP-based service, that's fine, that's their choice, but they shouldn't be forced to lose the functionality of the service that they are currently paying for at a comparable rate. So so if our phone company, for example, comes to my neighborhood and says, guess what, we're no longer offering phone service, this is the service you have to take if you want voice service at all, and by the way, it's twice as much as you're paying for plain old telephone service. We don't want that to occur, and right now there's nothing that we know of stopping that. So we want the FCC to weigh in on that and to make sure that basically a technology transition expands, not contracts, customer options. And that's obviously, our prime concern, that there's a functionally equivalent service at a reasonable or comparable rate that would still be available. The other concern we had, and this goes along with any trial, and the FCC has had several trials over the years, some of which have worked well and some of which haven't worked well, but that there has to be local readiness for the trial. There has to be a great deal of consumer education and outreach. The local governments and state governments need to be involved in this, and they should be willing participants in the trial so that they can support the educational outreach efforts to the consumers. And we also pointed out in this regard that in many cases the largest consumers of these services are local governments and the state government. My city, for example, relies heavily on plain old telephone service, and we live in Florida, so we're subject to a lot of storms and power outages, and it's important that we have plain old telephone service available for our public safety needs. So we want to make sure that if we're going to be part of something where that service is no longer available, that we're kept informed. And in that regard, we also commented that maybe the old technology should remain in place and a parallel system of an IP technology should be placed for the trial, that the system that people have come to rely on and expect to work should remain in place and shouldn't be taken down. There's a real concern in Florida generally, just, how many people have grandparents or parents who live here? Everybody, right? So thank you, Joanne. I know Joanne actually does. No one, really. Wow. You've taken them all off our highways. We appreciate it. But, most of these folks live in apartment buildings or condos that are very, very large and maybe older, and they've spent hundreds and hundreds of thousands of dollars on their wires and their electronics. And if the plain old telephone copper network that they've come to expect to provide the service for their elevators, for their alarm systems, for their emergency services, for their management offices is no longer available, what happens to that investment, and are they going to be in a position of spending hundreds of thousands of dollars now to upgrade to an IP-based technology and have fiber installed in their buildings and all new electronics, and is it really fair to make them have to pay for that? So that's an issue that we've raised as well, that how does that transition impact consumers, particularly those, particularly seniors and those that may not have the resources to pay for this transition. And as I mentioned earlier, we're very concerned about the effects of this on public safety and network reliability. As you know, the copper telephone network is independently powered, which is great when I keep referencing Florida and storms, but now New York and New Jersey have, the same experience as us, and it's a real issue. And Louisiana and Gulf states and every jurisdiction in the country now has some type of natural disaster that they have to deal with. Plain old telephone service works well in a natural disaster because it doesn't have to have backup power supplies and uninterrupted power systems. I represent a couple local governments in the Keys, and basically to save money, they decided to transition the telephone service to their fire stations to a VoIP service. And I've made sure that they realize that they have to have really robust, uninterrupted power supplies available, because when people want to call their fire station, it's usually because of some problem, and they have to get in, they have to be able to reach somebody, and if there's a storm that's knocked out power, that's not going to work. So people need to realize what they're getting into when they make these transitions from basically the legacy technology that exists today to a VoIP service. In addition to the policies that we talk about in terms of the FCC, and that tends to be NATOA's focus, or at Congress, the telecom policies that tend to be NATOA's focus, there are substantial policies that are outside of the FCC's scope of jurisdiction that we need to address with respect to this IP technology. And these are very, very important policies as well. Tim mentioned a little bit about taxes, that, but that's a big concern of mine. Obviously, I'm a local government official. And I served, actually last year, Florida has a communication services tax, which is a separate tax solely on communication services. And the legislature created a communication services tax task force that I was privileged to serve on, along with 4 industry members and 3 other folks who represented counties and cities in Florida. So what happens to these taxes and these fees that states and local governments have come to expect from communication services? It's pretty well established what taxes and fees you pay if you're providing plain old telephone service or internet service or video service or cable service. But when you switch to an IP-based service, it's not so clear. And also wireless services actually cause a lot of problems. Florida is supposed to, theoretically, obtain communication services taxes on prepaid wireless services, but the Department of Revenue and the providers and the retailers cannot figure out how to do that. We're talking millions of dollars. We're not talking about a small amount of money, and it's the fastest growing sector of the communications industry. So we're talking about states and local governments losing millions of dollars. You may think it doesn't really have that much of an effect, but Florida, for an example, is maxed out on its bonding capacity. Florida cannot issue any more public bonds, so forget about building new schools or anything. And because its tax that supports its bonding authority is the gross receipts tax, and it's been going down because gross receipts on communication services have been decreasing because people are switching to IP-based services or the wireless prepaid services. So it's not only affecting the state, but it's affecting local governments as well. Our revenue from the communication services tax has declined basically every year since 2008. And it's a substantial portion of our budget. In my city, it's the 3rd single largest revenue item in my city, behind property taxes and electric franchise fees. So it's a big chunk of money that is decreasing rapidly as people switch to these IP-based services. And some policymakers somewhere need to take ownership of this issue and figure out what to do with it, because it's going to become a big problem, not only for the states and local governments, but to all of our residents who expect us to still provide these services and don't want us to raise taxes. We talked a little bit, and you see all the time, about some of the criminal and other harmful activities that occur using communication services. And the laws have been in existence for basically a fairly long time with respect to what happens if you use a telephone or some other traditional communication service to perpetuate a fraud, to engage in criminal activity. The laws are not that robust or comprehensive with respect to IP-based services. For example, if someone posts a YouTube video about somebody that, winds up creating some type of fraudulent activity on that person's life, or creates some kind of hassle, for that person, is that criminal in nature? And who's going to pass those laws and look at those issues? And that's something that I think we need to catch up on. And we kid about the social interaction, when's the last time anybody here had a really good phone conversation with anybody, or as opposed to just text? Or was your first communication this morning with your family or friend, via a text or an email as opposed to a phone call or even an in-person message? And someone needs to take ownership of what the effects of this are with respect to the lack of social interaction and lack of communication skills. Actually, Chili's, I showed up there that it's obsolete. The newspapers no one reads the newspapers anymore. most people here probably did not find out about what's happening in DC at the Navy Yard via the newspaper. You found out via text message, most likely, or possibly on TV or some other form of communication. But Chili's announced today that they are basically not going to have waiters anymore. You're going to have a tablet on your table. You're going to see a picture of the food. You're going to order what you want, and you're going to swipe your credit card. And they'll also have games, that you can play while you're sitting there at dinner with your family or friends or whoever you're having dinner with.
I assume this means we don't have to pay a tip now.
Well, I was wondering what's the appropriate amount to tip your screen? I don't know. And they were careful to say that you cannot get your first round of drinks via the screen because they have to proof you to make sure you're old enough. But unless they'll probably figure out a way to swipe your license or something and check your ID that it's actually you. But my other half and I play a game. We're out to dinner with friends. We put all our smartphones on the table, and the first one who picks up their iPhone or whatever has to pay the bill. It's not a big thing, but how many times do you sit at restaurants and you see people directly across from each other texting, they're not talking. And so there's got to be some issues associated with that, or maybe that's a good thing, I don't know. But it's something, it could be a good thing. It's just something to think about as to where we're going and what other issues that's going to affect. For example, Chili's announced that this is going to occur in over 1,200 restaurants, that they're replacing their waiters with these screens. So how many people are going to no longer be employed because of the change in technology, and what does that affect? So these are real serious issues that we joke about, but you wonder if you're going to forget, when's the last time you had a conversation with your neighbor? Do you even know who your neighbors are? When's the last time you had a conversation with your neighbors across the fence? Or the last time your kids actually got together and played a board game as opposed to texting each other or playing some type of online video game? And are we going to forget about quality, support, price, value, service, and is loyalty totally out of the communications business? Because if you can get the functionally equivalent service from a myriad of providers, how does any provider, or how does a consumer, for that matter, have any type of loyalty to any one brand? And speaking of which, I need to thank Comcast for the mints, and I'm grateful that you no longer have a contract with my city, because if you did, as an elected official, I'd have to pay you for them. So thanks very much. And I don't know if we have any time for any questions. Okay, thank you.
And now, folks, you have a great opportunity to ask two experts your questions about what the IP transition means for local governments. If you have a question, to make it easier for our folks that are watching this on the web, if you'd step up to the microphone here in the middle of the room, say who you are, where you're from, and go ahead and ask your question. But please take advantage of this time to ask these folks some of your questions.
Rob Billingsley from Arlington County. Just a week ago, we had this hearing with Verizon and FCC, and while it was billed much about the net neutrality, it also, I believe, included some arguments about the scope of authority that the FCC has. And so one of the key issues I think you brought up was about the definition of basic service. In light of the arguments, and who knows how that's going to turn out at this point, that were done a week ago, what role does the FCC have in that definition of basic services?
Those are some of the issues I talked about. Without going into detail about the open internet appeal and the oral argument, I think it is likely that the court will say that the FCC has some sort of jurisdiction over broadband, if for no other reason because the Communications Act gives the FCC jurisdiction over all communications by wire and radio. And however you call broadband, it fits in that. The issue is, and by the term basic, I assume you mean telecommunications service, in other words, just pure information transport. The issue there is if the court were to hold that the FCC can't use what's called its Title I ancillary jurisdiction to impose sort of common carrier light regulations on the broadband, which is in essence what they tried to do in the internet. If that is barred by law, then the regulation of basic availability of service and rates, the only way the FCC could get there from here, absent congressional action, would be to redefine broadband transport as a telecom service. Some of you know that that was an option on the table when the FCC began this proceeding. Putting aside the the law, and that would certainly be challenged in court, there's also the political reality. The issue is to whether, to do that, the FCC would have to make the decision, have 3 votes to do that. And I think the political likelihood of that is small. So that leaves the question, the short answer to your question is, likely the FCC will be the only authority, absent a change in federal statutory law, that would have the authority to do that. And in theory, I think they could. They could deal with some of the issues Gary talked about, even as an information service. But it depends on what the scope of their authority is to do that. Curiously, if they were to redefine it as a telecom service, as opposed to an information service, then the commission actually might not be able to deal with Gary's local issue, because under the current act, intrastate local service is beyond the FCC's jurisdiction, and it cannot regulate that service. So you have that sort of weird twist.
I would agree. I mean, I think federal law needs to change, because currently, as I indicated in my first slide, technology or regulation does not keep up with technology, and it never has. But the FCC is, I mean, although there's been several court decisions that basically say the FCC has any jurisdiction that it decides it has, that may not hold with respect to some of these IP issues. And I don't think that the FCC does have the authority or the political willingness to go beyond these silo regulations that have traditionally existed. Right now, it doesn't seem willing to do that. And they're looking possibly for change in the law to do that.
Mitzi Herrera, Montgomery County, Maryland. Gary, I want to ask you, when you say that Florida does not have a carrier of last resort, so I want to understand as a practical matter, let's say that I am a resident who moves into something like this, a new community built on drained swampland somewhere in Florida, right? And it doesn't have an existing, a reason I mentioned it, doesn't have an existing copper network that got there.
Right.
So now I want to have phone service. One is, do I have a right to actually have phone service?
No. And there are many people in your situation who move into communities who do not have phone service. In the traditional sense.
I don't have right to POT service.
No.
Do I have a right to an offering? Is there someone who's required to offer me something, whether it's VoIP, cell phone?
No, because the state franchising law as well doesn't mandate any build-outs. And so the cable company is not obligated to build to you. The phone company is not obligated to build to you, and wireless companies certainly aren't obligated to provide wireless service to you.
Now, I'll add the policy justification in Florida and elsewhere for these is that you don't need the requirement because the marketplace will take care of it. I'm not saying I agree with that. The argument is everybody can get this, and it's available everywhere, so you can get it. So what's the word?
Is that a flip phone?
Talk about obsolete, right?
But the point is, that is the policy justification. I don't necessarily agree with it, but that's the policy.
But Tim has a chip in his head, so it just communicates that way. But it is.
Okay.
And we're being facetious here.
Let me follow up on that. So now let's say somehow I have a means of communication in my home that has no cell phone cable service, or I guess the question is broadband. The question would be, if you say that we don't have a requirement because the market will solve that. My question is, if there's a market failure, who do people turn to in Florida?
Well, there have been. We all saw with the Connection bankruptcy, what happened, and there were communities served by Connection who received notices saying your services will be turned off, and they were the only service in those communities. And so I called one of my good friends who serves on the FCC IAC committee with me, who's the chair of the Florida Public Service Commission, and said, these people do not have service after this date. Can you do anything about this? And he said, absolutely not. We don't have any jurisdiction to do anything about this. So it's you beg and you borrow and you steal and you try and go out to providers and convince them that there's money to be made by extending their plan and building service to these communities. And if you can do so in a very, very quick amount of time, because these are real problems that are going to occur quickly, I have a situation now with a community about 300 units, mostly seniors, because they provide, it's a retirement community, and they also provide assisted living services. And their cable company is going bankrupt, and they've never built broadband services, so they provide just traditional video, and people rely basically on wireless service for everything else. But it's a real problem. I mean, when there's no obligation by a wireline or even a wireless provider to provide services in communities, it's a real situation. It's a real issue.
So I guess the last one would be, if the Florida State Commission doesn't have any authority to address it, would those be complaints that people would file at the FCC?
Do they have authority to address that?
That's a question for Tim.
Well, I mean, you could file a complaint. The problem is, and some of you have probably heard of Fire Island.
Right.
The issue for the FCC is historically on the telecom side, the universal service obligation, that is that your local telephone company serve everyone, is a state-imposed obligation for intrastate service. The only federal hook on Fire Island, there's not a federal obligation for telephone companies to extend local service lines. That's a state-imposed obligation, but the hook in Fire Island was the local network also provides interstate access services, which are within the FCC's jurisdiction. That was the hook. So, I mean, that is the way you'd have to go after it. Or, the flip side, broadband information service, you could try to use, say there, but the problem is there is, even under the FCC's open internet order, there is no retail obligation to serve imposed by that order by the open internet order. So if you're talking about obligation to serve at the federal level, well, that's very hard to get to.
But I will say also, I mean, some folks have gotten very creative at getting services, and the marketplace is there to some extent for these folks that want to be very creative. A neighbor of mine in a very, very rural area didn't want to get the traditional phone service or internet service from the only local phone company around, and there is no cable company there, so the only video service is satellite or an IP-based video service, and they basically purchased a wireless modem through one of the big wireless carriers, and he's got Apple TV and gets over-the-top services, and that works well enough for him, but it's not cheap. But it was a solution that worked well for him. So some people have gotten very creative at getting services when there really are no traditional services around.
Great, thank you.
Thanks.
I'm just going to say very briefly, we got to talk about this some more, because I'm not convinced the FCC is as helpless as y'all seem to think. There are a fair number of statutory hooks. I'll also point out that every common carrier that is offering an interstate service right now is required to file a Section 214A request for discontinuance before they discontinue. Mm-hmm. And if they are not doing so, then they are in violation of federal law, and people should file with the FCC. I think that frankly, being based in Washington, D.C., I can say that one of the biggest problems that is confronting policymakers around this is no one knows what goes on outside of the Washington, D.C. Beltway. Right. And this is a huge, huge problem. And I think that if the scope of the problem were made more clear, there would be more impetus to actually take some action.
Right. No, I appreciate that. And that's part of the function the IAC is supposed to serve, because you're right. I mean, these senior staff members of the FCC and the commissioners don't live outside of the Beltway, and they only think that everything that they know comes from their own experiences within the Beltway, and that's not true. And that's part of our function, is to educate them as to what happens in the real world.
No, I would agree. I mean, when I said the FCC is helpless, 214 is a classic example. The fact of the matter is Verizon was over talking to the FCC for the Fire Island. By the way, although they're now going to say they're going to build FiOS in Fire Island, there still is New Jersey. I can't pronounce the name. It's your home state. Yeah, where they're not. There was a 214, although I think Verizon spent, no one knows, because it was pre-proceedings, so they didn't really have to file complete ex partes. There was back and forth between the Verizon and the Bureau staff about whether they even ever needed to file a 214 at all, But because the Fire Island service termination received such publicity, and obviously there was an issue under state law, the New York Public Service Commission, that it caught enough attention that Verizon did file. Interestingly, I'm not aware of AT&T having filed any similar discontinuations in the several states like Alabama, Mississippi, and elsewhere, where they have been allowed to give up their carrier of last resort obligation. Whether they file, I don't think they have filed any 214s.
We certainly
for
haven't
that,
received
but,
notices that they have, which we're required to do, so.
And folks, we're going to have time for one more question before Rick introduces himself. Our last questioner was Harold Feld of Public Knowledge. Harold will be speaking on a panel right after lunch, I believe it is. So make sure you tune in and come back for that session. But Rick, if you'd go ahead.
Rick Elwatt, Fairfax County. To follow up on Mitzi's hypothesis, let's suppose that no one will serve my recently drained swampland, but I happen to be Bill Gates, and I'm willing to build my own system or have my newly formed town build a system. I'm just curious, in Florida, is that possible? Are those sorts of municipal or private systems viable?
I mean, yeah, Florida makes it difficult for local governments to build networks and provide services. You have to go through a lot of regulatory hoops, but there are several that have done so. I mean, it's expensive. You know, so typically, as you've seen in other places of the country, it's the municipalities with their own utilities that do so and do it successfully. Others haven't. Ever since the whole Wi-Fi, you know, public Wi-Fi craze kind of died down, a lot of local governments have sort of abandoned that effort. And when, with the economy being what it is, you know, when it became a choice of paying police officers and firefighters versus building Wi-Fi, you know, we paid for police and fire. So. But we can do it, it's just, it's not prohibited, it's just regulatorily challenging.
Thank you.
And I'd just like to ask you to join me in thanking Tim and Gary for taking time out of their schedules today. And we are on schedule here, so please, I believe we have a box lunch available out in the lobby area, and I believe the next session starts in this room at 12:15. Thank you.
Hey, Tim, this worked out great. Thanks so much.
Thanks, enjoyed it.